In a negligence case, or in a medical malpractice case, or even a car accident case, when a case goes to trial and now the jury is evaluating your case, does the jury have to sit there for days and days trying to make sure whether or not your case is 100% certain that what you are saying is true? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is no. The jury doesn't have to sit there for days and days trying to figure out with 100% certainty that what you're saying is true. Instead, they only have to understand that you are more likely right than wrong. You only have to show as the injured victim that you are more likely right than wrong and what you are saying is true. Now, what does that really mean? It means that when you're proving your case, you only have to tip the scales ever so slightly, just a little bit more than 50%, to show that you are right and that what you are claiming is true. And once the jury believes that you have shown that you are more likely right than wrong, they then go on to answer the next question, which is, was the wrongdoing, was the carelessness a substantial factor in causing and bringing about your injuries? If the answer is yes, they will next go on to damages, which is how much money to award to you. Let's say for your pain and suffering, for your economic losses, as well as the non-economic losses known as past and future pain and suffering. So one of the key questions that you always have to remember is that when an injured victim comes into court and they're asking a jury to award them compensation for the harms and losses that they suffered because of somebody else's carelessness, what we have to show is that we are more likely right than wrong and that the jury does not have to sit there for days on end making 100% sure that what we are claiming is true. Instead, the law only requires that we show that we are more likely right than wrong, just tipping the scales ever so slightly. And by the way, that's a totally different requirement than, say, in a criminal case. In a criminal case, that burden is so different from what a prosecutor has to prove. They have to show beyond a reasonable doubt, which is a much, much higher burden. Instead, we only have to show that we're more likely right than wrong. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process in a case involving a medical malpractice matter, a wrongful death matter, or even a car accident matter. I realize you're watching this video because you probably have questions of your own. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.